Good afternoon, everybody. My name is Reinhard Bütikofer, and I am welcoming you to what promises to be a very exciting webinar. We have invited you, and I'm glad that you have been able to join us for the launch of a study that presents some legal analysis of the EU-China Comprehensive Agreement on Investment. And I will introduce the authors of the study in a second, but let me make a few introductory remarks. As everybody knows, the Comprehensive Agreement on Investment, or CAI, is presently in the deep freezer. And that is not because of any particular stance that the institutions in Brussels might have been taking on the substance of the study, but because of the sanctions that China has leveled against members of the European Parliament. And we were, even the advocates of CAI were very clear that we cannot accept that we would be called upon ratifying a deal with a country that does not respect the European Parliament. But then that does not imply that the whole discussion over CAI is over and done with. Quite the contrary. There is repeatedly, there are efforts from the Chinese side to push for early ratification, they say, as early as possible. They always imply that it's to the European benefit, and then you start asking yourself, why are they pushing so hard if it's our benefit, but whatever. But also there are European voices advocating that. For instance, President Charles Michel, the president of the European Council, over the weekend in Munich, responding to questions from the audience, also spoke up in favor of the ratification. He forgot mentioning the European Parliament, but we'll talk to him about that. So against that backdrop, we found in the Green Group and in the international relations group within the Green Group, we found that looking at the substance of the deal is still well merited. And we have already authorized a couple of studies before. You may have also looked at those, but now we have a study that does some legal analysis. And it looks, for instance, at issues like national treatment commitments. It looks at issues like national security concerns and how they intersect with the economic level, dispute settlement mechanism. What is it worth? What could we expect of it? How does the Chinese corporate social credit system interact, or how would it interact with CAI? And last but certainly not least, also it looks at the sustainable development section in CAI and tries to establish the merit of that. This whole work has been done by a group of academics led by Alessandra Arcuri, who is full professor of inclusive global law and government at the Department of Law and Markets, Erasmus School of Law, Erasmus University in Rotterdam. Professor Arcuri is also a member of the Erasmus Initiative on Inclusive Prosperity and of the Erasmus Institute for Public Knowledge. Her research and teaching focus on international economic law, sustainability, risk regulation, and global technocracy combines with her academic research, where she has engaged with non-academic publics also by authoring commissioned reports or briefing institutional actors, including the Dutch Parliament, the Dutch Ministry of Foreign Affairs, the European Commission, and NGOs. Professor Arcuri has been visiting fellow at the European University Institute. She has been teaching also in New York University, Hamburg University, and many other institutions. A second member of the team is Associate Professor Federica Violi, who is Associate Professor in International Law at Erasmus School of Law, where she also acts as PhD coordinator for the Erasmus Graduate School of Law. Dr. Violi received her PhD in International Law from the University of Milan La Statale with a thesis on land grabbing and permanent sovereignty over natural resources. She's been a visiting researcher at the Max Planck Institute for Contemporary Public Law and International Law in Heidelberg, and at the Columbia Center on Sustainable Investment in New York. Her research focuses mostly in the area of international economic law, investment contracts, international investment agreements, and due diligence. Dr. Violi actively lends her expertise to inform institutional practice and NGO activities, and has recently appeared as an expert before the Italian Parliament. And then we have Assistant Professor Ioannis Kampourakis, who is Assistant Professor in Law and Markets at Erasmus School of Law, Erasmus University, Rotterdam. His research addresses the role of law in global production and economic governance, covering questions of legal theory and political economy, international economic law, comparative economic regulation, transnational private governance, and business and human rights. And then there would have been a fourth member of the group, Stephanie Triefus, a PhD candidate. Unfortunately, she cannot join us today for imperative reasons, but also her part of the work will be presented by our three professors. Before I pass on the floor, let me make just very short technical remarks. Q&A and chat functions are open. Please use those channels if you wish to, and I'll pick up your questions later on after the presentation, because we're planning on having a Q&A section of this webinar. Short live questions might also be possible if you raise your hand with the raise hand functions. We will end the webinar at 3 p.m. sharp, but the PowerPoint that is going to be shown now and the study itself, respectively, the link to the study will be sent by email to all the participants of the webinar. So thanks again to our three experts for the work they've been doing and for the willingness to present that to an interested audience. And now I pass the floor to Professor Arcuri to get us started on substance. Please.
Thanks for the kind introduction. Actually, we have a reverse order. Professor Violi starting the presentation.
Thank you very much for the very kind invitation, and thank you also for the very kind introduction. We're pleased to be here, and we will present to you today the salient features of the study that we have submitted on the legal analysis of select issues under the EU-China Comprehensive Agreement on Investment. Now, the CAI is considered to be a sui generis agreement. It's neither a typical investment agreement nor a typical FTA. In fact, it does not include rules on exchange and trading goods, and it does not address investment protection standards. What the CAI does is focusing on market access and non-discrimination for investment and services, which means that investors and exporters will have an easier access, an enabled access into respectively the EU and China market. Now, of course, the CAI does not operate in a vacuum. There is a broader context and a broader regulatory framework that is relevant to the EU-China relations. More specifically, we're thinking here of the WTO agreements, but also potential proposed EU anti-coercion or anti-subsidy instruments, the EU Magnitsky Act, and not to mention the recent request for consultation filed by the EU at the WTO for the dispute around the Lithuanian goods. Now, very briefly on the scope of the study. As said, we did focus on a select number of issues, more specifically on national treatment commitments with a focus on new energy vehicles. We have looked into national security concerns and risks of political coercion to move then to the dispute settlement mechanism and suspension of obligations and conclude with the sustainable development chapter. Without further ado, I would like to give the floor to my colleague, Ioannis Kampourakis, who will show how the CAI liberalizes investment commitments and ensures national treatment.
Thank you very much, Federica. And hello, everyone. Thank you. So indeed, one of the cornerstones of the liberalization of investment that the CAI guarantees is the extension of national treatment for covered investments. National treatment is introduced as a general rule in Article 4 of Section 2, and it introduces pre-establishment commitments of equal treatment. Of course, it is also subject to several reservations, some of which are strictly defined and some of which allow for broader margins of discretion. The reservations feature in Annex 1 and 2 of the agreement in the form of negative lists. Annex 1 lists 36 entries in areas such as exploration of minerals, telecommunications, or manufacture of transport equipment, and is subject to a standstill and ratchet clause. This means that future amendments to the limitations listed are also exempted from national treatment obligations, but only if they're less restrictive than the limitations prescribed in the CAI. In addition, subsequent unilateral measures that liberalize the market above the levels prescribed by the agreement are locked in and cannot be reversed. Annex lists 17 entries for which China is not restricted to liberalizing amendments, but can also actually adopt more restrictive measures. These entries also form the so to say hardcore of national treatment reservations and include fields such as social services, cultural heritage, and atomic energy. Among the entries of Annex 2, we paid special attention to the provision for new industries, which is entry 15, in which China reserves the right to adopt measures with respect to a new industry based on a definition that leaves significant interpretive space. And this is a provision that could potentially have implications for emerging industries, for example, in the fields of artificial intelligence, blockchain, or robotics. Federica, could we change the slide, please? Thank you. So to fully appreciate the potential scope and the depth of the liberalization of investment under the CAI, one of the tasks we undertook in the course of compiling this report was to compare the CAI to China's unilateral foreign investment law of 2019. The foreign investment law also establishes a regime of pre-establishment national treatment for foreign investors, guaranteeing the same treatment as to their domestic counterparts. Importantly, according to Article 4 of the Foreign Investment Law, if more preferential treatment is offered to a foreign investment under an international treaty or agreement like the CAI, such treaty or agreement takes precedence. And therefore, insofar as the CAI sets provisions of higher standards of market access for foreign investors, then they take precedence over all other provisions, including the unilateral foreign investment law of China. In terms of extending national treatment obligations and market access commitments, the CAI does not make great strides in comparison to the foreign investment law. However, one sector where the CAI includes concrete concessions that go beyond the foreign investment law in its negative list is that of medical institutions. While the foreign investment law provides for foreign investment in medical institutions only in the form of equity joint ventures, the CAI establishes an exceptional regime for EU investors allowing them to establish wholly foreign-owned private hospitals and clinics in 8 Chinese cities and 1 area. Another sector where the CAI makes a concession that is new in comparison to the foreign investment law is the field of telecommunications. More specifically, the CAI allows EU investors to invest in data centers or cloud services with shareholding ownership limited at 50%. The cloud market, we also suggest, could prove an important field for future investments, especially as the data of Chinese citizens must be stored in mainland China. Besides these concrete new concessions, the most important advantage, we would say, of the CAI is, in comparison to the foreign investment law, is its non-unilateral basis as a binding international agreement. So unlike the foreign investment law, the commitments that form part of the CAI cannot be revoked unilaterally, while most exceptions to national treatment obligation, like I said just before, are subject to a standstill and ratchet effect, which means that any future amendments must be less restrictive than the standards established by the CAI. Could we move to the next slide, Federica? Thank you. So one emphasis area in our report was the field of new energy vehicles, where the CAI outlines a specific regime of market liberalization. The importance accorded to new energy vehicles, or NEVs, by political and industry actors alike, I think should be understood in the context of 3 interrelated factors. The first is that the automotive sector accounts for one of the largest shares of EU foreign direct investment in China. The second is that as part of the European Green Deal, the EU has committed to a complete shift to new energy vehicles by 2035. And finally, the interest in new energy vehicles in China specifically relates to China's own success in establishing the largest currently new energy vehicle market worldwide. So as of the end of 2021, the country had a total of 7.84 million new energy vehicles in use, with NEVs making 15.7% of the country's car market. China also produces about half of the world's plug-in electric vehicle batteries and has developed a very deep homegrown battery manufacturing supply chain. So a question that emerges from this is, how has China become a global leader in this market? And perhaps not surprisingly, this has been a result of a coordinated government-led approach, which involved subsidies. So financial subsidies were provided to encourage NEV procurement through direct payments to approved auto manufacturers, regulatory incentives, and most importantly, that is immunity from car ownership and traffic restrictions. And maybe it's worth providing a brief background for those that are interested but might not be familiar with this. In order to alleviate traffic pressure and urban congestion, a number of cities in China have imposed purchase restrictions for internal combustion engine vehicles. And two major policies have been advanced. The one is a license plate lottery, where residents must take part in a monthly draw to get the license plate. That's the case in Beijing. And the license plate auction, where residents need to bid and pay for the license plates. That's the example of Shanghai. So crucially, the purchase of new energy vehicles is exempted from such restrictions. And in addition, new energy vehicle drivers are exempted from driving restrictions that apply in major cities. And according to empirical research, it is these regulatory incentives that have been the most influential for the consumer uptake of new energy vehicles. A third strategy is the recent new energy vehicle production mandate, which sets annual mandatory requirements for new energy vehicle credits for auto manufacturers. And that mandate is part of a new strategy centered around a market dominance. So the current new energy vehicle industry development plan focuses on creating a unified regulatory environment, securing market competition, and promoting, in quotes, the survival of the fittest enterprises, that's actually a direct quote, and supporting the industry through infrastructure development. So a central part of the current plan of China's development of the industry is the phasing out and ending of the subsidies, and instead shifting to production mandates, taxation exemptions, while maintaining subsidies for charging infrastructure. And this showcases a shift away from directly instigating consumer demand, which was the case until now, and towards advancing the general infrastructural and regulatory conditions for the new energy vehicle industry to flourish. Part of China's success in new energy vehicles can be attributed to attracting foreign investment. It is in this context that we should read the CAI's provisions. The characteristic example that I suppose most of us are familiar with was the cooperation with Tesla that started in 2018 when China changed its negative list to enable wholly foreign-owned enterprises to build new energy vehicle plants in China. For China, Tesla functioned as a catalyst that enhanced local competitiveness, and as Tesla increasingly sources key components locally, indeed now over 90% of recent Tesla models are sourced locally, the spillover effect it can cause is projected to deepen and strengthen the Chinese electric vehicle supply chain. Federica, could we move to the next slide, please? Thank you. So what does the CAI do to liberalize investment in NEV manufacturing? Well, first of all, the CAI specifies that new energy vehicles do not fall under the general reservations assumed by China against national treatment obligations in the automotive sector, and that is joint venture restrictions, which are anyway planned to be eliminated in 2022 this year. The CAI does impose certain more specific limitations on market access for new energy vehicles investors that have to do with overcapacity in a given province. Yet, this does not affect existing automobile manufacturers in China that expand their business and shift from internal combustion engine vehicles to the production of new energy vehicles. The limitations related to regional overcapacity are not framed as exceptions from national treatment, but as limitations to market access. However, and that is important, these limitations are lifted across the board when the total investment for the new energy vehicle project is above $1 billion. This is Annex 10 of the CAI. A systematic interpretation of the role of the annexes played in the agreement confirms that this annex, Annex 10, is legally binding for the contracting parties. The rationale of the provision is to intensify cooperation in the field of new energy vehicles between both parties. Cooperation may not be concretely defined in the agreement, but from the preamble, as well as from secondary policy documents, cooperation should be understood as having both a commercial and a political dimension, while the urge to intensify such cooperation should be understood, we suggest, primarily as aspirational and less so substantive. In addition, Annex 10 is subject to a ratchet effect, which means that if China chooses to further liberalize access to the new energy vehicle market for foreign investors, for example, by lowering the 1 billion threshold, this new unilateral liberalization does not become part of the agreement and can always be reversed back to the 1 billion threshold. A final point concerns the extent to which Annex 10, this 1 billion threshold for lifting limitations, can benefit solely EU-based enterprises, as it could be argued that the concession would have to be extended to all other WTO members on the basis of the most favored nation principle. However, manufacturing operations are beyond the definitional scope of GATS, and as such, most favored nation commitments do not apply. Just to conclude this section with a brief note on the limitations that might arise from the liberalizing model with regards to the NEV investments. Well, it's a brief assessment in terms of opportunities and limitations for EU investors. Investment projects below the threshold of $1 billion, which might be unlikely in any case, face primarily limitations associated with capacity limits. And as capacity limits and targeted output are set by the government, ad hoc regulation in different provinces may discourage foreign investors. As mentioned, limitations related to overcapacity also favor businesses already operating, which have also captured a significant part of the market share, presumably. As far as limitations for investments above the $1 billion threshold are concerned, well, the threshold will exclude, of course, startups or small and medium-sized enterprises. And EU manufacturers may still face general limitations related to the domestic regulatory environment and to infrastructure development, for example, battery manufacturing. And this includes dependence on Chinese value chains. And in that case, the example of Tesla that I referred to before may be illustrative. So I would now pass the floor back to you, Federica. Thank you.
Thank you very much, Ioannis. And we will now move briefly to national security concerns in the context of the CAI. It is well known that specifically the Chinese understanding of national security was one of the issue of the matter of concerns around these agreements. And if one wants to look to the definition of the Chinese notion of national security, this is to be found in the National Security Law of 2015. And the provision therein is quite encompassing. It includes the sustained development of the economy and society beyond what are the more traditional understanding of national security, right, like territorial integrity or other types of emergencies. Now, this understanding of the national security is intimately connected to the idea that economic growth and development would prevent social unrest and guarantee, indeed, a peaceful coexistence of the society. This definition was not the Chinese definition up until the beginning of the 2000s. This is a new definition that has been introduced in connection to the accession of China to the WTO and its entry into the global market as a major commercial partner. Now, while this expansive notion is typical to the path towards liberalization of China, this is also in line with a global trend of securitization of economic relations and has, of course, quite an impact on a very high amount of sectors, of trade and services sectors. In this context, what is particularly relevant for the CAI is the recent release of the measures for security review of foreign investment, which were indeed adopted in December 2020. And while China already had, at the level of domestic law, a security review mechanism for mergers and acquisitions, these measures for security review extend to direct and indirect FDIs, and most importantly, on greenfield investments. And what these measures do is basically indeed operate a review in the pre-establishment phase of investment into China. The interesting aspect here is that the sectors that are covered is a wide array of sectors, and they are also widely or broadly defined. We have, for example, major equipment manufacturers, important infrastructures, important cultural products, key industries. So there is obviously a certain degree of discretion that the working mechanism, which is indeed the NSR authority that will overview the security review, can enjoy. There is, however, a qualifier. The broad scope of application is coupled with an actual control of the investee, which is defined as having, for example, 50% of the equity in a certain company, or alternately exercising an influence on the decision-making of the investee company. This leaves, in any event, quite, as I said already, quite some discretion to the working mechanism. And the question is how the measures interact with the CAI. In fact, interestingly, they are not explicitly referred to or carved out in CAI, either on the main text or in the relevant annexes. So one might ask, do they still apply to the liberalization commitments stipulated in the CAI? And this is an extremely important question because, of course, as all FDI screening, including the one of the EU, they might circumscribe market access or other national treatment commitments. So it's important to understand whether and how the measures affect the implementation of CAI commitments. Now, there might be two alternatives how the measures would still apply to the liberalization commitments stipulated in CAI. And they do have quite a difference in terms of justiciability. The first one is that the parties might decide to include an explicit carve-out in one of the existing or potentially to be negotiated annexes that specifically excludes the measures on both sides. So the EU FDI screening mechanism or instrument and the measures, the Chinese measures from the CAI, or the measures any governmental action adopted under the measures might be justified under the security exception clause in section 6 for the protection of essential interests. Why is this important to distinguish these two alternatives? Well, in the first case, so if there is an explicit carve out, or if these measures are included as non-conforming measures, the arbitration panel under the CAI will only be able to assess whether or not a certain action, governmental action adopted under the measures is within the scope of the instrument. So it would be just a mere check on to whether, yes, okay, this specific action falls within the ambit of the measures. There might be even a possibility that the measures are excluded from the dispute settlement mechanism. That's the case, for example, in the Chinese-Australia FTA. In the case where the measures are not explicitly carved out from the liberalization commitments, the arbitration panel might instead engage in a substantive review of the measures and test them, assess them against the requirements in Article 10. Now, why is that important? In the first case, as I said, it would just be a sort of a procedural review as to whether or not the measures fall within the scope of the instrument. In the second case, there would be a substantive review, an objective review. And the CAI arbitration panel has to take into account, in that sense, relevant WTO case law. And the WTO case law, when it comes to the security exception, is clear in the sense that this exception is justiciable and it's not self-judging. There are objectively accessible criteria that have to be met. Most importantly here, China has held exactly this position in the Russia transit dispute just recently. So China itself has submitted a third-party submission, indeed, to the dispute in Russia transit, considering that the security exception clause has to be assessed objectively and restrictively. So if we are to consider that the CAI arbitration panel has to follow WTO case law in this regard, of course, this would be possibly the most stringent review over a governmental action adopted under the measures and protect, let's say, the integrity of the agreement. Now, of course, the measures are not the only concern around national security or around the risks of other risks of politicization and coercion in the context of the CAI. Before entering into the specifics, I would like to mention, for example, that just recently an unreliable entity list mechanism has been introduced as mostly as a response to the US UAV saga, but it does apply all over the board. And this basically gives the possibility to Chinese authority to level sanctions against companies in a sort of anti-boycott instrument or anti-boycott fashion. Now, in order to limit the risk of politicization and coercion in the context of the CAI, the agreement includes level playing field provisions. So there is an explicit prohibition of forced technology transfer, both at the level of conditional treatment and performance requirement. There is a specific article on the transparency of subsidies, which interestingly goes beyond the subsidies and countervailing measures agreement and the GATS, which excludes indeed an obligation to notify subsidies in the context of services. And there is also an all-encompassing access to judicial review when it comes to all type of governmental actions, also at the level of legislative action, which is also very interesting. Now, these, especially, for example, the prohibition of foreign technology transfer, were already included in the foreign investment law, as Ioannis has already mentioned. What the interesting aspect is here is the bilateralization of obligations, which makes these commitments obviously less retractable. There are, however, some aspects that still remain problematic. For example, in the context of the forced technology transfer, this might be ordered by a court or an authority to remedy distortion of competition. And there again, this leaves, of course, some discretion to the competent authorities in this realm. There are also other types of favorable treatment to covered entities, so SOEs, that are not excluded from the CAI. For example, favorable access to production factors. This is all to say that politicization cannot be completely removed as by way of legal means. So these provisions are certainly a progress, and they do provide a reliable legal framework. However, there might be still other ways by which companies might suffer less favorable treatment. And in this context, one should look at the corporate social credit system. The corporate social credit system basically includes aggregate data from both the market and regulatory authorities that monitor the behavior, the conduct of companies, both at the commercial side and regulatory side. What is interesting is that the corporate social credit system does not show, at least according to several studies that have been conducted on the issue, a direct or indirect intent to discriminate against foreign companies. And it does not include extra substantive obligations for them. What it does, however, is making compliance with certain norms more immediate and efficient. Now, I should add here 2 points. First of all, we don't have at the moment one single national corporate social credit system. There is a legislative instrument that is currently circulated internally, and there is the intent to make the corporate social credit system a unified national instrument. However, at the moment we have a scattered set of systems, both geographically different and also sectorally different. Most importantly, what is problematic in terms of the corporate social credit system is not the system itself in terms of substantive obligations, it's rather the types of norms and obligations to which it ensures obedience with. So the problem is rather the underlying substantive rules that the corporate social credit system aims at implementing or at monitoring. Also, interestingly, the reliable entity list, as well as the measures for security reviews of direct and indirect investment, might be included in the corporate social credit system. So this might be a way by which de facto foreign companies might be disadvantaged in relation to Chinese companies. However, the direct infringement of CAI provisions for the corporate social credit system is a different question. If we want to look at direct infringements, then we have to look at the level playing field provisions that I mentioned before. So provisions on transparency, clarity, timely publications of laws, and most importantly, access to judicial review, as there is evidence that especially in certain geographical areas of China, access to judicial review for the removal, for example, from the blacklisting under the corporate social credit system has proven highly problematic. Can measures adopted, so blacklisting mainly, adopted under the auspices of the corporate social credit system be justified under the CAI? They can. And they can specifically under Section 6, subsection 2, Article 4, which basically replicate Article 20 of GATT, which is an exception on public morals. And if the intent of the corporate social credit system is to verify the trustworthiness or untrustworthiness of companies and the orderly functions of the market, well, then an exception on public morals might well work, of course, if these actions are adopted in a non-discriminatory manner and for necessary reasons. There are other problematic aspects related to the corporate social credit system that are not addressed in the CAI. And here we're thinking of data collection, privacy, digitalization, cyberspace, not to mention, as I hinted at before, other aspects, for example, human rights compliance or environmental compliance that are partially addressed by the CAI, and we will see how in a minute. Now, very quickly on the dispute settlement, I will not dwell too much on the key features. In fact, the CAI dispute settlement mechanism is mostly replicating either dispute settlement mechanism like the China-Australia FTI, but most importantly, the WTO dispute settlement mechanism. It has a system of consultations, mediation, mutually agreed solutions, and arbitration. If consultations failed, the complaining party can immediately request arbitration. And the arbitration panel shall recommend in its report the responding party to comply with certain obligations in case of violation, in case of non-compliance. If consultations between the parties fail, the complaining party may request compensate when we request a compensation, an agreement to reach compensations, or should also the latter fail, suspension of obligations might be initiated by the complaining party, either in the same sector, which is called retaliation, or in a different sector, which is called cross-retaliation. Now, what is interesting about cross-retaliation? First of all, cross-retaliations in goods is excluded from the CAI. In fact, the CAI does not, as we said in the beginning, does not include any rules on trading goods. So cross-retaliation in the context of CAI means retaliation in other industrial sectors or in trade and intellectual property rights, which are also included under the CAI. Now, cross-retaliation, while possible under the agreement, still operate in exceptional circumstances, and possibly even less so in the context of the CAA. In fact, cross-retaliation is typically justified because of a great trading power imbalances between the two parties, the complaining parties and the responding party, which is not something that we have really in the EU-China relationship. Furthermore, there are some doubts as to the EU law compliance with cross-retaliatory measures, specifically with those cross-retaliatory measures that might implicate expropriation of locally established enterprises, so in the post-establishment phase. When one wants to look at the effectiveness of a dispute settlement mechanism, it's very difficult to do so just based on the architecture of the dispute settlement mechanism and the rules of the agreement themselves. We can derive certain conclusions but based on the fact that the dispute settlement mechanism indeed replicates mostly the WTO dispute settlement mechanism, and this has been considered to generate a remedy gap. Because indeed compensation is only prospective, meaning that the responding parties might continue for a long time to not comply with the commitments it has under the WTO agreements. So if a criticism can be leveled against the CAI dispute settlement, is mostly the same as the one we do have for the WTO dispute settlement mechanism. Finally, it's important to say that parties have a choice of forum. They can either go before the WTO dispute settlement mechanism or the CAI dispute settlement mechanism. And that's the same for other EU FTAs, but also for the China-Australia FTAs. Interestingly to say here is that Australia and China have both preferred to go before the WTO over the state-to-state dispute settlement in the China-Australia FTA agreements, which has never been used so far. And a final point is that the dispute settlement mechanism of CAI excludes quite important sectors. For example, the obligation of transparency on subsidies at Article 8 and the Sustainable Development chapter. And this will be reflected upon by Professor Arcuri.
Thank you, Federica. Thank you, Ioannis. So let me conclude this presentation with few remarks on the CIA section on investment and sustainable development, which has been heralded as a major breakthrough of the agreement. This section, very briefly subdivided in 4 subsections. The first sets out the context and objectives. The second deals with the environment. The third with labor. And the fourth with what we could see as an emasculated dispute settlement mechanism. Next slide, please. Subsection 1 offers important context, identifying the number of key international documents with regard to sustainable development as Agenda 21 and so on and so forth. You can see in the slide, and recalling the importance of CSR and all the most relevant instruments in the field of business and human rights. Overall, these rules are hortatory and vague, although they can be important for interpreting other provisions of the CIA as per Vienna Convention on the Law of Treaties. The subsections on environment and labor, so the next subsections, next slide please, are not very ambitious either, as they are mainly focusing on the right to regulate, which is already included in other EU trade and investment agreements, and include aspirational jargon, such as the parties shall strive on achieving high level of protection. Despite an overall dismal framework, there are at least two provisions worthy of note. The first is Article 6 of subsection on the environment, which stands out for establishing obligations related to the Paris Agreement. And here, for example, it provides that each party shall effectively implement the UNFCCC and so on and so forth. And this can be an important contribution in the path towards achieving sustainable development. And so it's an important norm. Also because China has been criticized for its NDC, but the 2020 have slightly improved. However, this norm would be relevant when there is also a strong dispute mechanism settlement, which, however, is relatively weak. When we shift to the part on labor, next slide, please. This is certainly one of the most controversial dimensions of the agreement with China, relating to its poor track record in respecting human rights, and most relevant for treaties on economic relations, labor rights. Now, maybe some of you have already picked up from the news, but there has been recently released a 2022 report of the ILO Committee of Experts on the application of conventions and recommendations, where the committee has expressed deep concern about the labor policy applied in Xinjiang region. So how is this subsection addressing the alleged poor track record of China vis-a-vis labor standards? Let's see, this next slide, please. This subsection generally reassert the commitments of respecting treaties already ratified by China and introduce a rather loose commitment to make continued and sustained efforts on its own initiative to pursue ratification of the fundamental ILO Conventions 29 and 105, so those on forced labor. And the recent dispute, which has already been discussed widely in debate about CAI, between EU and Korea regarding labor issues, is relevant to understand the potential implication of on CAI subsection on labor. So in this dispute, a panel concluded that the absence of explicit targets on expected milestones towards ratification implies that the party has a certain leeway in selecting the ways to make these efforts. So such findings suggest that the obligation to make sustained and continued efforts to ratify certain ILO conventions in CAA will be hardly enforceable. At the same time, what is interesting, the panel has pointed out that the commitment to respecting, promoting, and realizing the principles concerning the fundamental rights constitute substantive obligations for the parties, which include, among others, the right to freedom of association. Now, here I would like to link to one presentation given at CEPS in January 2021, where also Dr. Butikofer was present, in which Dr. Sabine Weyand, Director General of DG Trade, noted the relevance of this ruling for the China investment agreement and said, and I quote her, "Even without ratification, Korea, and the same applies to China, is bound by the principles of the ILO, and so there is already a commitment. We have to intelligently use that and work with the Chinese to say, if you want to have a ratification of this agreement in Europe, something has to happen between now and when the vote comes." Now, given the recent report by the 2022 ILO experts, which I just mentioned, it is to be wondered whether the conditions for ratification are not lacking at the moment. Next slide, please. So let me conclude with few words on the subsection on the dispute settlement mechanism. This subsection, which is similar to other TSD chapters of European FTAs, provides that when consultations over a dispute are not coming to a good conclusions, the only remedies is follow-up consultation. So basically, this section offers only a slimmed down version of the dispute settlement of the remainder of the agreement. There are some strengths to this section because the panel includes a variety of expertise, such as international labor and environmental law experts. There are some quite good rules on transparency, and the agreement contemplates the possibility of submitting amicus brief. At the same time, there remains important weaknesses. So there is a lack on rules on remedies, what are commonly called sanctions. There are no sanctions. And one of the supporting arguments by the Commission is that this is not good for dialogue, but there are at least two counter arguments. One is that remedies or sanctions and dialogue are complementary, they don't substitute each other. And the other, maybe more important, is that all the remainder of the agreement is subjected to suspension of concession. So in other words, the traditional remedies, sanctions. So not to include this in the section on sustainable development seems to put the sustainable development goals on a subaltern plane. Next slide, please. So while we were asked to give an answer on the question of whether the sustainable development section may facilitate achieving sustainability, and such an answer is rather speculative, but at least our analysis suggests that this section is rather weak and unlikely in itself to lead to transformative change, let alone carbon neutrality of China by 2060. At the same time, we should add that the section on sustainable development could still have positive value because it could create a forum for socialization where common narratives are forged and progress towards sustainable economy could be constructively discussed. And I thank you for your attention, and we conclude the presentation here. Thank you.
Thank you very much to all three of our presenters. We have still 36 minutes remaining for the Q&A and the wrapping up at the end. So ample time for everybody to come in and share either their questions or their inquiries, their comments, their concerns, their even criticism. And the first person that I see raising his hand is René Repassi, a new member of the European Parliament. Welcome, René. Can somebody unmute René?
Yes, just a moment.
Okay, I think now it works, doesn't it?
Yes, it does work. Welcome.
Okay. Yeah, not sure whether also my video can be seen. If so, then people would realize that I have the same background as Dr. Violi. Yes, so thanks a lot. This is indeed a very curious situation for myself because I'm now in my new position here as Anna Pytikova said, a member of the European Parliament, but I have still my position as professor at Erasmus School of Law, Erasmus University of Rotterdam, where I'm currently sitting because we have the green, meaning free week. So I'm at Erasmus University, listening in my function as member of the European Parliament and the EU-China delegation to a legal presentation of my colleagues from Erasmus at Erasmus University. So pleasure for this interesting situation. But it was also a pleasure to listen to my colleagues on this highly interesting study, which is, I believe, a core contribution to the discussions that we're going to have on this treaty. And I would like to raise some questions to all of you that are now deep in there, because ultimately, like always with this kind of agreements, it's a balancing act. What speaks in favor, what speaks against it. Now, the very last part presented by Professor Arcuri speaks a lot against this agreement, since we are having here discussions on due diligence reporting, corporate social responsibility, corporate sustainable responsibility, and the question of how environmental standards and labor standards are treated in China is here at the core. So therefore, my question goes to Professor Arcuri, my first one. Is there, it's a more political question, I have to admit, but is there actually any progress to the status quo that we can see if this agreement were to be adopted? Or would we even see some backlash if this were to be adopted, given the current efforts that we might observe, seeing the global movement to more corporate sustainable governance codes, etc., due diligence reporting that we see not only in the European Union, but also in other member states. I just speak of Lieferkettengesetz in Germany or something like this. That is the first one. The second one probably goes best to Dr. Kampourakis. It is on issues that are highly relevant for the internal market, looking at from a consumer protection perspective. I would just make the example of children toys that enter the European Union market, which are underneath EU standards, are hardly controlled and are then harmful when being purchased on obscure platforms. So to which extent does the agreement provide any possibilities to actually enforce and control higher European standards and goods that are coming then from China, especially if you are now under some kind of pressure to liberalize and to open borders. The second one goes in a similar field. We are currently having big projects in regulating digital markets, and we do have players from China that are active there. And to which extent efforts that we do to have very stringent regulation on digital markets will be somewhat undermined if this agreement were ever going to be ratified, and what were rights then from the Chinese investors in the European Union that can be derived from this article, from this agreement, that might have certain effects on how we regulate our digital markets. Thank you.
Thank you, René. While your colleagues are going to address your questions, I would encourage all the other participants to also share their questions or raise their hands, and we will then go according to the sequence of remarks that are requested. Who would want to start? Can I start with Professor Arcuri, please?
Yes, sure. Well, thanks for the wonderful, although very difficult question to answer. Would the ratification of this agreement move us a step forward, a step backward, or possibly just let us stay where we are? And that is a very different one, because on the one hand, the section, I don't think I speak necessarily against in commenting on the sustainable development section, but it is under ambitious. Having said that, we know that Europe has various instruments is using at the moment, such as the human rights sanctions, and at the macro level, I would see a complementarity between the regime of the human rights sanctions with sustainable development chapters of economic agreements, because the sanctions target individuals, whereas doing work at the level of economic agreements would entail addressing the problem at a more systemic level, which I don't think the human rights sanctions do, although they may be seen in the bigger picture as part of a certain strategy. So I wouldn't want to underemphasize the importance of this dialogue that is created through this new mechanism, but they remain under-ambitious. So if they would be strengthened, and at the moment, to my understanding, this is not the idea to reopen the negotiations on the text. Besides, I don't know how realistic that would be with China to get even to higher or to a better deal than what the Commission has done. So here there is also a lot of appreciation for the work on the Commission on this chapter, but still it's not a section that has high promises, nor it has high disadvantages in a sense that would move us backwards. I don't see it as an extreme. I see it as something in between, in a strategy that still is far from perfect when it comes to trying to work on more sustainable economic relations.
Thank you. And who's going to pick up the other questions?
I can take it. Yeah.
Okay, good.
Yes. So thank you very much, Professor Paz. I think the first question on the internal market is also very timely, considering the discussions that have been going on about a potential ban on products that involve forced labor. That has something that is being discussed right now. Well, as to whether the CAI provides any mechanism of control for subpar goods or goods that might involve forced labor and so on, well, in fact, it doesn't, because it's it only concerns services and not goods. So in that sense, it's not the kind of instrument that could help the EU, let's say, border its internal market and secure optimal standards. As far as the second question is concerned about digital markets, yeah, this is, I would say, quite complicated. I think there is a political dimension to it, to which I cannot really speak. So it might be that certain actors, foreign investors from China, introduce, let's say, different type of market values, if you will, to which the CAI in itself is agnostic and therefore does not provide any mechanism for prohibiting this or controlling it. But one perhaps interesting element that could be added to this discussion with regards to whether and how could the CAI protect the internal regulation of the digital markets is that maybe we could read the CAI in conjunction with the current proposal for an anti-subsidies instrument discussed at the proposal by the European Commission, whereby foreign investors that benefit from subsidies, even indirect subsidies, would have to notify accordingly. So it provides a mechanism of, let's say, certain control of actors that could possibly come from the digital environment in China and benefit from state subsidies. So I think that's just an interesting element that could be added in responding to this.
Thank you. I have a number of questions and asks for the floor. I will first read 3 questions from the Q&A section from Esther Cañada Amela. First, could you walk us through how enforcement of level playing field clauses like on tech transfer, SOE standards, would work in practice? Could you walk us through how it would work in practice? Second question, how do you assess the value of China's technological neutrality commitments for ICT? And third question, could you talk a bit about the European commitments? What does China gain? And then there are quite a few other people who also want to take the floor, but I go with those 3 questions first, and then I return to the others. Please.
I can answer the first, certainly the first, and then let's see with the other two. Well, the question of implementation and enforcement is always the sort of the big question when it comes to international agreements. We see in the regulatory framework section of the agreement quite detailed obligations, and these are both obligations of conduct and obligations of result, and they are, most of them at least, are justiciable under the dispute settlement mechanism. Now, what it means in practice, there are still quite some exceptions, especially for SOEs, as I hinted at before, for example, sort of a preferred access to capital, production factors, or other type of tax exemptions. They still exist in the context of covert entities, or transparency of subsidies is excluded from dispute settlement. So even for the forced technology transfers, there are certain exceptions. So it would have to be assessed on a case-by-case basis how exactly the obligations are enforced. What is interesting, I think, here is to say is that departure from these obligations would have to be justified. So the agreement, the commitments existed already in Chinese domestic law, but the fact that they are incorporated and enhanced in the agreement makes it particularly forceful in the sense that departure might be subject to a dispute, which is never something that parties like to engage in. When it comes to, I think there was another question that I can quickly answer. Maybe I don't know whether Ioannis, you want to take on what does China gain? Yeah, there was also another question in terms of particular gains of China. One that I can certainly mention because it was referred also in terms of national security and coercion, etc., was the access access to visa and permits of senior managers, which was apparently particularly difficult for Chinese individuals to gain, but maybe Ioannis, you want to pick on the services that China would have a particular gain on.
Yes, thank you, Federica. So as we studied mostly the side of the Chinese, well, actually the annexes and the national treatment reservations for China, then I would feel more of like an expert in that regard. But I think what could be added to the discussion about gains of China to this, well, other than market access and national treatment obligations from the part of the EU, I think what could be added is the discussion I mentioned also with regards to new energy vehicles, for instance, well, the issue of there is something to be gained from the cooperation, also from attracting foreign investment. And this is also the example I was getting to with the issue of Tesla. So building an internal market, for example, in the new energy vehicles, which is where I focused for the study, was mediated by attracting foreign investment. So it's not only the benefits for China that might be accrued through the CAI are not only about China's access to the European market, but also about facilitating and attracting European investment. And of course, there is, I think, a more political undertone to this. There was in the preamble, there's talk about intensifying cooperation and so on. So I think there is also a discussion to be had in terms of geopolitics and what could China gain with regards to this.
Well, if you allow me to add 2 sentences there, I think indeed there are some distinct gains for the Chinese side. For instance, when we would, according to the draft agreement, grant them national treatment in the media sector, which China refuses to reciprocate on, then there are gains in the political realm. Obviously, and this has been commented a lot upon in the public debates, that for China this may be an attractive deal because it could help sort of driving a wedge between the United States and the Europeans. But that certainly goes beyond the scope of this study, and we would have to address that in a different context more deeply, maybe. I would like to call upon another number of participants who who signaled that they have an interest in raising issues. So I will first call on Anna Saarela to come in, please. You're now unmuted. Please talk to us.
You might have to unmute again, Mrs. Saarela.
Well, if that doesn't work at the moment, then maybe we come back to you and go to another participant first. Mantiao Chur has raised his or her hand. Would you please take the floor, and we will then try to return to Mrs. Saarela.
Can you hear me?
Yes.
Thank you. Thank you very much for the speakers for this very timely discussion. I have just one question, which is probably a little bit away from the center topic you've just mentioned. I also noted that the DG Sabine Wayad has mentioned in a number of meetings that the CAI is just one of the instruments or policy in its policy toolbox. There is a box of different instruments, and then, of course, this is not all. And the EU is actually, as far as I can see, is taking very active steps in making a different kind of instruments. So my question is that how would you position this treaty, CAI, in the bigger scenario of the toolbox? Let's say, how would you expect the CAI would interact or be used in combination with some other existing instruments or potential future instruments adopted by the EU, especially with regard to the enforcement of the Sustainable Development Chapter? Thank you very much.
Thank you, Mr. Chair. Who is going to field that question?
I could start, and then maybe my
Yeah.
colleagues could join me. As indeed, this is a very important question, broad question about the strategic autonomy of the EU. In many respects, this agreement can be seen as complementary to other instruments we have. First of all, to come back to what does the agreement cover, and it is about liberalization of investment. So it's not only what has been termed as sui generis, but it's interesting exactly because we do not have too much of this type of agreement. So it's neither in good, where we have mainly WTO, FTAs, nor protection of investment, although there is a rendezvous clause, and maybe we can discuss about that as well. But it's about, in a sense, I would say this agreement is also about the details of market access. So on how to gradually liberalize. Vis-a-vis other more recent instrument, it's still about bilateralism, so negotiating, working together. Other instruments could be seen as part, on the one hand, of a new industrial policy of the EU, and on the other, on being more serious unilaterally in promoting human rights and sustainable development more generally. So I would agree with some of the statement of Dr. Weyand that the agreement in many respects complements instruments that either we have or we are thinking of adopting, also rules on transparency. In that sense, I think this is something that ought to be considered again, all of this is in the background of a very delicate geopolitical situation on which, as lawyers, we cannot comment too much. I think our colleagues in the parliament are better positioned to do that. So I don't know if my colleagues want to add something on that.
Well, I tend to agree with that assessment, and I would quote Jörg Wuttke, the president of the EU Chamber of Commerce in China, who said that in his assessment, CAI on its own was a baby step at best. So it cannot stand on its own. It may play a certain role, and that has to be assessed in detail in the context of a wider policy, just as Professor Arcuri has said. I think that's basically a widely shared agreement also in the European Parliament. I have more participants here that have asked for the floor. Alexia Afia, would you want to take the floor, please? You offered to make a comment.
For that, you would need to raise your hand. Otherwise, we cannot give you the floor, please.
Okay, Alexia Afia, please raise your hand so that you can be given speaking rights. Yeah, now she raised her hand.
Yes. Hello. First of all, thank you very much for this wonderful presentation. I hope you can hear me.
Yeah.
Yes, that's great. So I wanted to first make a comment and then a question. So the comment really is to add to what China gets out of this agreement. And there's also a concession from the EU Commission, which relates to access. So basically, it's the one and only time we use reciprocity in the agreement, by the way, and it's from China's side. Namely that China will be granted 5% of our renewable market. And this has already started. So China has bought in Spain. And I imagine that that's below the 5% for the EU. It's not very clear whether it's a member state 5% or if it's an overall 5%. So that's one thing I wanted to add. And on the question really is the national security issue that worries me, because I didn't understand well whether China could use that clause to argue that new legislation, for example, the yes, I mean, whether the, sorry, now the word slips my mind. I'm sorry about that. It's late here in Asia. The anti-coercion legislation could be considered, against the spirit of that clause. So in other words, can China use that clause beyond what would be understood as encompassing the agreement? That's what I would like to know.
I now recognize your voice. That was Alicia Garcia Herrero.
Correct.
And good to have you, Alicia. And who would want to take that question? Please.
I can, thank you. Thank you for your question. Well, the analysis of the measures in the context of CAA would sort of give, make sense in if China would want to depart from complying with the liberalization commitments that are included in the CAA. So the national security exception, the general exception at Article 10, can only work if China would violate any of the obligation it has under the CAA. The question is, of course, whether the measures could be used to that extent. And for the measures, one has to look again back to the general definition of national security, which is included in the national security law. And that is very expansive. But for that to enter the framework of CAA, it needs to be coupled with a violation of the liberalization commitments included in the CAA. Does that make sense? So it only works in the context of those obligations, of these provisions in the CAA.
Yes, so it cannot affect any other legislation that the European Union were to issue. That's clear. Thank you.
So yeah. Of course, then if they want to use that strategically, so if they want to, if they decide not to comply with the CAA strategically for this reason, is another question. But
yeah, of course.
there needs to be but there needs to be non-compliance with the CAA specifically. Yes.
Okay, thank you.
Thanks for that clarification. Now I want to go back to Alessandra. We tried to give you the floor again. Please, your hand is up and you should now have speaking rights, please. Hello, Mrs. Sarela. I don't understand what the problem might be.
Otherwise, I would recommend to put it in the chat function. And there's another question in the chat function that you might want to, in the Q&A that you might want to pick up.
Would you read the question in the Q&A, please? I didn't find it. Okay.
In the Q&A is a question from Susa Ferenci. To what extent do you think the dynamics between Lithuania, China, i.e. China's increasing willingness to weaponize trade and use economic coercion will affect discussions on CAI inside the EU and the EU's willingness to further develop its defensive toolbox? Question from Taipei.
Well, I guess that goes more to me than than to Erasmus. I certainly would assume that the overall development of our complicated relationship with China will have an impact on the future of this agreement. We have already noted in the beginning that it is inconceivable that the European Parliament would even pick up the CAI for ratification unless the sanctions against the European Parliament would be lifted first. But of course, there are also increasingly voices from the business community that don't shout, but do say in a very, very serious way that what CAI deals with does not necessarily answer some of the most pertinent issues they have with China's investment and trade policy. So when you look at how China has been behaving under the rules of chapter, the China-Australia Free Trade Agreement, questions are, what protections would CAI, if enacted, give when chapter doesn't give any serious protections in many regards? Or what protection would CAI provide with regard to liberalization when, on the other hand, you have protectionist China first policies, like in the health sector, where the Chinese authorities mandated that procurement should focus on privileging Chinese industrial providers. The German Chamber of Commerce just published their annual report. They had a business confidence analysis, and they came up with the result that a large number of German businesses in China feels that they are being disadvantaged under China first policies of different stripes, and they feel that this is increasingly a problem. So I would say that while CAI sits there waiting for China to move, China moves on other fronts. China implements new policies like the anti-sanctions law, like the data management law, which have far-reaching impacts. And the question, maybe this is a tilted view from my point of departure, but I would say the question of how relevant the guarantees that the mostly weak guarantees that CAI would offer, how relevant they will be with regard to some of the new challenges is increasingly going to be an issue. I guess that this will have to be taken into account once we get there.
Maybe
if we get there. Yeah.
Okay, I think I of course I fully understand your answer, and if I can add my 2 cents as a very boring international lawyer on few reflection on the Lithuania case, but just like a minute, which clearly it shows that disentangling economic relations from more political relation is not an easy task, even when we have a relatively robust rule-based system established at the WTO and a relatively high engagement of China with the system, because I think this should be stressed that China has positively engaged with the international trade system. There is also a second reflection, I think, which is important and very general, not as eloquent as what Mr. Butikofer said, but I think it's still worth reflecting that the WTO continues to offer a venue for addressing some particular thorny questions with which members engage. So it offers a venue. And it is important on this point to note that the US and Australia have signaled their intention to support the EU. So this may be a reminder of the advantages of the multilateral setting of the WTO dispute settlement body vis-a-vis a bilateral dispute settlement mechanism. Be this one we are discussing, but also others. Again, this was a boring international lawyer's answer, but I think it is revealing of certain equilibria that are being shaped in the international law level.
Well, we're grateful we have some boring reason. We have not been able to give everybody the floor who would have liked to contribute, but we are coming to the end of this webinar. Let me first of all direct everybody to the chat where we have posted the link under which you can find the extensive study of the authors from Erasmus University. But we will also send the link proactively to all the participants of this webinar, and I will also post the link on Twitter. I want to thank our experts. I believe if you have a very hot potato, if you have a very intense political debate, some boring expertise is dearly needed. So thank you very much for having done this work and having contributed to an educated conversation and a rational conversation over these issues that will have a great bearing on not just the EU-China relationship of the future, but also our own industrial future. So with that, I again want to show my gratitude and also want to thank all the participants. And not the least, I want to thank my own team, in particular, Katrin Glastra, who has organized all of this and has worked with the authors to finalize the study and to prepare this webinar. Have a good day, everybody, and hope to be in touch in the future also. Thanks and bye.
Thank you.
Thank you very much.